For quite a long time there has existed the controversy as to whether or not international law is true law. Some jurists have argued that international law is positive law, whereas others have maintained that international law is only a body of rules of international morality. One theory that has enjoyed acceptance is the positivists' law that international law is not true law. John Austin, 19th century, is the main protagonist of this theory. Others who have questioned the legal basis are English philosophers like Thomas Hobbes, Jeremy Bentham, and the German jurist Samuel von Pufendorf. Austin argued that international law is not really law because it has no sovereign. His attitude towards international law was influenced by his theory of law in general. He defined laws properly so-called as commands of a sovereign. According to him, a sovereign is a person who receives the habitual obedience of the members of an independent political society and who in return did not owe such obedience to any person. Rules of international law did not qualify as rules of positive law by this test, and not being commands of any sort were placed in the category of laws improperly so called. According to Austin, international law was positive to international law morality, only analogous to rules binding a club or a society. Austin further described international law as consisting of opinions or sentiments among nations generally. Positivism has been objected to a number of grounds. 1. Modern historical jurisprudence has discounted the force of Austin's general theory of law because there is no legal system that conforms to his concept. Modern jurisprudence has shown that in many communities without a determinate sovereign legislative authority a system of law was enforced and being observed, and that such law did not differ in its binding operation from the law of any state with a true legislative authority. 2. Austin's views, however right for his time, are not true of the contemporary international law. In the last 1 century or so, a great number of international law rules has come into existence as a result of lawmaking, treaties and conventions, and the proportion of rules of primary international law has correspondingly diminished. Even if it be true that there is no determinate sovereign legislative authority in the international field, the procedure for the formulation of rules of international law by means of international conferences or through existing international institutions is practically as settled and efficient as any state legislative procedure. 3. Questions of international law are always treated as legal questions by those who conduct international business in various foreign offices or through various existing international bodies. The agencies do not consider international law as merely a moral code. In his Oxford Lectures in 1890, Sir Frederick Pollock sums up the issue in this way, namely, if international law were only a kind of morality, the framers of state papers concerning foreign policy would draw all their strength on arguments. But as a matter of fact, this is not what they do. They appeal not to the general feeling of moral rightness, but to precedents, treaties, and to opinions of specialists. They assume the existence among statesmen or publicists of a series of legal as distinguished from moral obligations in the affairs of nations. Furthermore, the legally binding force of international law has been severally asserted by the nations of the world in international conferences. For instance, the UN Charter is both explicitly and implicitly based on the true legality of international law, whereas Art 38 of the Statute International Court of Justice states that the function of the court is to decide in accordance with international law that such disputes are submitted to it. Austin confused rules of international law proper with rules of comites gentium, international comity, the later being rules of goodwill and civility founded on the moral right of each state to receive courtesy from other states. Non-observance of a rule of international law may give rise to a claim by one state against others for some kind of satisfaction, whether it be diplomatic in character or it takes the concrete form of indemnity or reparation. It is otherwise for rules of international comity, i.e. it does not give rise to a legal claim. The concept of the law of nature exercised a great influence on the development of international law. Several theories of the character and binding force of international law were founded upon it. The law of nature denoted the ideal law founded on the nature of man as a reasonable being, i.e. the body of rules which nature dictates to human reason. The essence and relevance then is that states submitted to international law because their regulations were regulated by the higher law, the law of nature, of which international law was attached. The traces of the natural law theory still exist today, although in a much less dogmatic form. The approach kindred to that of national law underlies the current movement to bind states by international covenants to observe human rights and fundamental freedoms, and provides justification for the punishment of individuals guilty of gross violation of human rights such as war crimes and genocide. Because of its rational and idealistic character, the concept of the development of the law of nature has had a tremendous influence on the development of international law. It has generated respect for international law and provided moral and ethical foundations. Its main defect, however, has been its aloofness from the realities of international relations, shown in the lack of emphasis of the actual practice of state in their mutual relations, although the majority of rules of international law originally sprung from these practice. Besides, the binding force of international law can be traced back to one supreme fundamental principle or norm expressed by the principles of pacta sunt servanda, i.e. that agreements between states are to be respected and carried out in good faith. Pacta sunt servanda is an absolute postulate of the international legal system and manifests itself in all rules of international law.